Linda started keeping the log in her second month at the practice because something felt wrong and she didn't know what to do about it yet. A patient would come in for a consultation. The billing code submitted to insurance would include a procedure that hadn't happened. It was small, initially upgrade codes, phantom consultations, services billed at a higher complexity level than delivered. By the time Linda understood what she was documenting, she had 847 entries. By the time she took it to an attorney, she had 4,000.
The False Claims Act allows private citizens called relators to file lawsuits on behalf of the federal government against entities defrauding government programs. If the Department of Justice chooses to intervene, the relator typically receives between 15% and 25% of the total recovery. The DOJ intervenes in approximately 25% of cases, but it intervenes in nearly all cases where the documentation is strong enough to make the fraud provable without extensive investigation. Linda's 4,000 entries spanning 7 years were extensive investigation.
Linda's attorney filed the complaint under seal, meaning it was not publicly visible while the DOJ decided whether to intervene. The investigation period lasted 14 months. During that time, Linda continued working at the practice, continued keeping her log, and said nothing. The DOJ's decision to intervene came with a request for Linda to be interviewed by federal investigators. The interview lasted 3 days. The practice owner had no idea any of this was happening.
The government's case identified 11,834 fraudulent claims submitted to Medicare and Medicaid over a 7-year period, totaling $2.8 million in improper payments received. With treble damages under the False Claims Act and civil penalties, the total exposure was $8.4 million. The practice settled for $4.2 million. Linda received 22% of the recovery, $924,000, as the relator award under the False Claims Act's qui tam provisions. The practice owner was excluded from Medicare and Medicaid programs for 5 years.
The 4,000 entries in Linda's personal log were the foundation, but what made the case ironclad was the cross-reference. Linda had also kept copies of appointment records from the practice's scheduling system, printed on paper each week, stored at home, and patient intake forms from her own patient interactions. When her attorney matched those records against the billing submissions, the fraudulent claims were documentable on a claim-by-claim basis, not just as a statistical pattern.
Linda had stayed at the practice for 7 years while keeping these records. She had stayed not because she was comfortable with what she was seeing. She hadn't been comfortable since month 2. She had stayed because leaving meant losing the evidence access, and she had decided early on that she wasn't going to leave until the evidence was complete enough to be actionable. That was the long game. 7 years of discomfort in exchange for a case that the Department of Justice would find impossible to ignore.
The practice owner, who had built the business over 14 years, lost his Medicare and Medicaid billing privileges, paid $4.2 million, and has not reopened. Linda, with the $924,000 relator award, spent 18 months as a consultant to a healthcare compliance firm helping other practices identify billing vulnerabilities before they become federal investigations. The log she kept in a personal notebook, updated every Friday before she went home, was 341 pages. Subscribe.